everyone. Thank you. Welcome to Dangerous by Design, Early Strategy and Case Selection in Roadway Injury Litigation presented by Furhad Sultani. My name is Cassie Slugich, and I am the Outreach Director here at the Strip Matter firm. Founded in 1945 in Hoquiam, Washington, we are proud to continue serving the community where our story began and also while operating our main office here in Seattle. The Washington State Bar Association has licensed Strip Matter Law as a sponsor for mandatory continuing legal education. And today's webinar has been approved for one law and legal CLE credit. To receive your credit, please stick around until at the end of the presentation where I will submit a poll where you can enter your bar number. Our presenter today is Furhad Sultani. Furhad is an associate attorney at the Seattle Strip Matter office. He currently has a diverse caseload focused on personal injury and civil rights, including roadway design, product liability, police misconduct, and insurance bad faith. So I'd like to welcome Furhad.
Good afternoon, everyone. It is a little weird talking into computers, so if anyone has any questions while we're doing it, Cassie's going to be monitoring the chat and feel free to use it. Let me share my screen so we can present. So I'm talking to you about highway design, roadway design cases today, and this is an introductory course, so we're not going to go into the nitty-gritty, but ideally, walking away from this presentation, you should be able to get an inkling if you have a roadway or highway design case. Um, the way we're going to do it is kind of a little bit of background on case selection and then go dive into three cases that we actually handled here at Strip Matter that I've worked on to just kind of give you a flavor to drive the points home. One of the reasons I think highway design and dangerous roadways are so intriguing is because you're really dealing with communities and how to create a safer community. Um, we know public safety is not a market force, that there's no supply and demand with the right amount of public safety for the right amount of efficiency. But when you're looking at highway design cases, you're oftentimes looking at easy fixes that the government should have taken, or issues where the government caused an issue to be a factor. And so you're kind of there to call balls and strikes and say, well, this should have been done. And ideally, you're impacting community safety on a greater scale, because there's more thought put into our roadways. And I think Washington State has some of the best um, standards for us to be able to go after the government for dangerous roadways. And that's actually at our firm, we have Keith Kessler to thank, who's a bit of the guru on this. So I've been lucky enough to learn from him. I want to start off by kind of just giving a brief overview of how you're going to be looking at cases. And so because of the amount of expense that's required for highway design cases, they often have to involve serious injury or death, which makes them more complex. They're longer cases. There's a lot of discovery that's exchanged. You're reviewing a lot of documents. It's more complex because you're not only do you have the tortfeasor, but you have another set of attorneys. Um, and as we all know, the government tends to move slower. There is engineering standards you have to look at. So you're interacting with your experts more because you're trying to build your case up. And really what these cases come down to is foreseeability, whether the government was put on notice that this was a dangerous condition. And in that way, it's somewhat similar to a products liability case. They're resource heavy, like I talked about. You're going to be taking a lot of deposition, both fact and 30b6 depositions. When you're building your case, you're kind of getting into the nitty-gritty of how the government operates, which is exciting. You're seeing who the different players are, and how w- the right hand might not always be listening to the left hand. And in many cases, it's because of this inefficiency or this bureaucracy that these mistakes happen. Um, and so let's look at how to identify a viable claim. Serious injury is key. Not only serious injury, but inadequate insurance. And so it's just not feasible to take your clients through a highway design case if there's other avenues to ensure that they're fully compensated. And so what you're looking at is typically the policy limits are inadequate because of the injury, and it warrants the level of expert costs that are going to be associated with the case. And then you're looking at whether a defect was created or ignored by the government. And we'll get more into this, misfeasance or nonfeasance. You'll see a lot of this in roadway and highway design cases. Now, misfeasance is a act that caused the negligence, and nonfeasance is kind of just plain up ignoring the problem and hoping it doesn't have a bad outcome. Both are bad, but what you really want to focus on is misfeasance. The legal standard in highway design cases, as you'll find in the WPI, the 14001, the government has a duty to provide roadways reasonably safe for ordinary travel. And I'll take ordinary travel first off. Um, we're not looking at cases where there's, to borrow a product's terminology, where there's misuse. So we're not looking at abnormal factors. You very, very high rate of speed is outside of ordinary travel. Versus normal speeding, that's still in the realm of ordinary travel. And what is reasonably safe is a jury question. So it's a question of fact, and it's answered in the light of the totality of the circumstances. So we're looking at kind of everything in that community and neighborhood. And this is where it's going to be really important to look at whether there's a pattern of other instances. Is this particularly an unsafe road roadway? And what's really nice, well, not nice, but you're able to gather a lot of this information because similar collisions, you're gonna be able to find them when you do a public records request. And so when there's multiple instances versus say, you know, in the same county, a couple streets down with a similar intersection, you're not seeing those comparable rates, you're gonna start delving into the unsafe neighborhood versus whether it's safe. I wanted to use my first case example to illustrate that a lot of you probably already have a roadway design case. You might not be trying it as a roadway design case, but just because the facts are that a lot of times these dangerous roadways lead to higher instances of collisions, you might be handling a smaller case where it is a confusing intersection and there's an element of roadway design, but because the injury is not severe enough or because there's adequate insurance coverage, you're not trying it as a roadway design. The first case that I actually initially looked at as a highway design case and opted not to involved a pedestrian on a crosswalk. He had actually a green walk sign, but the way the roadway was configured, the north and south was diagonal with an intersection going east and west that kind of crisscrossed it. And the arterial street, the main street, had a stoplight where this intersection was. And then there was a stop sign where the defendant in my case was turning. They were taking a left turn. But because they couldn't see the light, they didn't know whether there was not going to be any pedestrians. And so in that case, it looks like a driver motioned to the defendant to turn, and without looking to see if there was pedestrians, they took a left turn into our client. He was clearly visible. He had a neon vest, a white helmet. It was in the early morning hours, but you could tell that this intersection probably needed either a four-way stop or a signal on both ends. It was not a slow intersection, and it was very hard to see around the corner. In that case, the vehicle that had hit our client was adequately insured, so it was a commercial vehicle, and the injury didn't warrant doing a full-blown highway design case. And so it's kind of interesting when you start to know what to look out for, you're going to notice a lot of your cases actually might be highway design and is an extra avenue for you to hopefully open up access for your client for other forms of compensation, especially when insurance isn't adequate. And so in that case, it just wasn't economically practical. It also prolongs the case. And we were able to secure very good results without going after um, the roadway design in that case. But it's kind of just fun to look at and see, okay, we have this collision and going out to the site and seeing, well, this is actually kind of confusing. It's a little weird that you have this going on, pulling the incidents incident history. And some of these lower speed collisions aren't going to result in a severe injury. Um, and so they can go unanswered for a long time. But what's really nice now is there's actually a lot more reporting going on. And so you're seeing communities make complaints when it's really hard to use a roadway. But I thought that was an interesting example of something that could have turned into a highway design case, but didn't in this instance. Well, when you're first investigating whether you have a highway design case, the things you want to do are one, you really want to go to the scene. You want to see what it looks like. And immediately from going to the scene, you might be driving around and using that same area where the incident happened, and you'll notice other cars either not getting the idea of how to use it, or you'll notice you might notice ring cameras now that are everywhere. So I'm going to actually take this out of order and go to witness development. I find it really helpful in a lot of my cases to go and knock on doors or talk to businesses in the area, see if they have cameras, see if they've had other histories of collisions there. And, it's so easy now to take photos. A lot of the people, if they're businesses or neighbors will take photos, post them on social media. There's apps like Nextdoor, um, or they'll post videos of other similar collisions. And so you can gain a lot of information from the community. And then obviously you want to do public records requests. So you want to gather crash data, design plans, whether there's been any other upgrades in the neighborhood. So oftentimes putting up a signal, so like a signal in one area might back up traffic in another and cause uh, traffic rates to go up, which might impact this particular intersection you're looking at. And so you want to gather a lot of information and also complaints. So this is also where you can find potentially more witnesses. The crash data is also really nice because you'll get a history of them and you'll be able to contact the parties involved and just give them a call up, learn about the facts of those collisions and whether it's similar to your collision that you're dealing with. I say smart, draft smart. We know that public records requests are taking longer than ever to get. So you want to be broad, but at the same time, you want them actually to relate to your collision. So requesting nearby collision and crash data and traffic studies is important. Maintenance requests for nearby intersections, but don't go too broad. And like I said, note recent projects because that might change how an intersection operates. And I want to touch briefly on the MUTCD. So this is the Manual of Uniform Traffic Control Devices. This is a great starting point. It defines all the federal standards for traffic controls, and it's very easy to read. You'll go and you'll look at your particular intersection, your crosswalk, your closure, and you'll try and find a analogous one in the book. And it'll give you examples of best practices that ideally will support your claim of an unsafe design. Oftentimes it'll kind of go through A, B, C, D. If you see A and B, you should install a signal. If you see A, C1, and C2, you should install a signal. But there's a lot of gray area. And this is where conversations with witnesses, conversations with your engineer, understanding the history of a location becomes really important. So we'll actually touch on one of my other examples in a bit, but I want to bring up one point from that, and that's that COVID and area enhancements often change what you're going to see from the traffic rates at a particular intersection, which can determine what they're looking at for whether the MUTCD requires a specific signage or requires a specific traffic control device. So in that instance, you oftentimes average a 3-year data pattern out to decide whether, for instance, a stoplight should be installed, a four-way stoplight. And so it'll say, well, if you have this much traffic going east-west and this much traffic going north-south, for and the average of that 3-year period, you need to install a four-way or a stoplight. And what wasn't being taken into account was that one of the years they were looking at was COVID. And so obviously the traffic in that area plummeted during COVID, but they were still using a 3-year time period. And so this is where engineering judgment really comes into play because you're able to ask an engineer, well, we're looking at averages so that we don't look at outliers. But if you have an obvious outlier, you should remove that data. And if you're looking at maybe this should be put in place, well, your argument is much stronger when you're saying, yeah, it met the requirements for year 2019 and year 2022, but it missed in this gap where we knew traffic rates were down low. Um, but I think really the MUTCD is there to back up your claim. It's not gonna be as easy as yes, I have a claim or no, I don't, because there is a lot of gray area. But what you're really gonna want to ask yourself about this intersection, is this a known pattern? Or is this a kind of one-off, doesn't really fit a pattern? And a lot of that gets, you know, thrown out when you're looking at the specific facts of your case. And so this kind of delves deep into the foreseeability. And ultimately, you're going to make your argument to a jury if it gets there. And so, yes, we're talking about the MUTC, what you should do. The engineer is obviously going to know it in a more intimate setting. But realistically, it's going to be those community members that are going to know whether something was dangerous based on how they're going to look at it. So a bad driver's decision is not going to defeat your ability to go after a dangerous roadway. It might make it a little bit harder. There's probably, I mean, since we're still dealing with a joint and several liability structure, you might get 95% on the defendant driver and 5% on the government, but that's all right, especially if your plaintiff has clean hands. Um, a lot of these issues, the tortfeasor is going to be primarily at fault. But the government has to look out for kind of known dangers and they must anticipate foreseeable misuse. And so if there's, say, a roadway has a history of speeders, it's kind of there's a curve in it, but leading up to the curve, everyone's going fast. There's a large rate of collisions. Everyone in the community knows, hey, you should do something about this. Install something, provide adequate warning, do something, maybe do rumble strips so that they're slowing down in the lead up to this turn so they're not veering into another lane. So when you start to see those patterns of this isn't one, two, three, four, this isn't just my client, this is multiple instances of the same thing, the government has an obligation to prevent that misuse from happening. Uh, I'm actually my next case is a really good example of this. So this was a closure on Lake Washington Boulevard here in Seattle. During COVID, they closed the roadway they do it during the summer. It's bicycle Sundays, and they did a full closure during COVID. Well, in that case, you had a lot of drivers ignoring the closure. And because it was so flagrantly ignored, it was endangering the community. You saw a lot of community members come forward and make lodge complaints saying this something needs to be done. It needs to be better signed. You need to actually, if you're going to advertise it as a full closure, make sure that it's fully closed. And actually, the roadway, so our client ended up, he was jogging next to some of his friends in the early morning, and a drunk driver hit him in the closure. The drunk driver had clearly gone around the closure. He was able to kind of just zoom. It was obvious that there was a closure, but I mean, his testimony and testimony of other individuals from the city was that the closure was being ignored by the public. And I think the community complaints really made this case because there was a safer alternative, and that was actually just to completely close off the roadway so through traffic could not come in. And you were able to do this because there was no need for through traffic. So the area of Lake Washington Boulevard where our client got hit, between the opening and the other opening, there was no access points that cars needed to go to. There was no homes on the roadway. And so you could have made an easy fix that would have kept the public safe. Even though obviously shouldn't be drinking and driving. And it was pretty obvious that the tortfeasor was going to bear the burden of responsibility. There was an element that the city probably should have gone that step further and prevented these interactions between the public and drivers. And they didn't take that step, even though they had been put on notice. And so that's kind of an act of nonfeasance. Well, we'll get more into that. By initiating the closure to begin with, there was some misfeasance. And that kind of dovetails in my next topic, which you're going to see a lot, is this misfeasance versus nonfeasance. The government's always going to argue there was nonfeasance, they just didn't do something. But it was really the tortfeasor's fault. And you'll be able to get liability there, but the more compelling argument was that the government created the danger. Like in the example I said before, the government was put on notice that this closure was not okay. So there's nonfeasance. But also, the government enacted this closure. They told the public it was safe to come out on the streets and use it for recreational purposes, but they failed to adequately close it. And there was, since the beginning of the closure, instances of vehicle and pedestrian incidents, not to the level of injury that we saw here, but because of how many reports were provided, we were able to go back and look and say you were put on notice. And not only that, but you publicized that this was all fine. And you had kids going on here. So you kind of, you're gonna want to try and convert a nonfeasance into a misfeasance, at least to tell that narrative and that story. And um, yeah, just looking at the history of an intersection, how it's changed over time, you're going to be able to see how you can tell that story better. And this brings me to my last case example. This happened over in the neighborhood of Fife. And the Fife neighborhood, if anyone knows, lives there or lives nearby, has exploded in population in the last 5 to 10 years. There's a lot of individuals moving there. There was a lot of road improvement going on. So a lot of road closures. And the area where this happened not only experienced a large population growth, but because of construction projects on, I believe it was Highway I-5, and I'm gonna get it wrong, but one of the highways, there was vehicles using their GPS and using this roadway that experienced was in a residential area and had experienced very little traffic up until that point. They were using it as a cut through. And so in the previous years before the incident involving my client, this intersection had become unmanageable. And neighbors were attempting to leave their houses nearby. They couldn't turn. There was long lines of traffic. In fact, an intersection 1 block up, so just a little further up, had dealt with a similar issue. And in that case, a police officer complained and they put in a four-way stop. And the four-way stop regulated traffic. So there wasn't a two-way stop and then just vehicles blasting through. And so, unfortunately, in our case, there was a lot of collisions involving cars misjudging the stop sign and waiting for a long time before they could turn. And so, trying to sneak their way in, which caused collisions. It was a lower speed road, but because of the cut through traffic, people were using it at higher speeds. It was kind of a disaster waiting to happen. And in fact, a lot of community members had signed petitions to get a four-way stop implemented. The neighbors of the area right outside where the collision happened had taken photos of other collisions. They had written their representatives. So there was a wealth of information in the community. In fact, people had said it's only a matter of time before someone gets severely injured or dies because of this. And instead of doing that easy, cheap fix, it would have taken less than a day and less than $1,000 to install a four-way stop sign. I think it was actually 2,500 maybe. They ignored the complaints. There was a 3-year period of traffic they were looking at. It didn't account for the fact that one of the roads was a dead end, and therefore it was never going to get up to the right traffic count. And it didn't account for the fact that one of the years was a COVID year. And so you saw traffic rates plummet. But the MUTCD had pretty much put this in a gray area of whether they should have installed the four-way stop or not. And in this case, our client was traveling down the lane that was not governed by a stop sign. And the lane governed by a stop sign, the driver misjudged and ended up trying to go straight quickly and hitting our client. Our client went off into the bushes. It was a family of three in the vehicle, and the elderly gentleman, passenger, ended up suffering a spinal cord injury and ultimately dying. And so and where a younger, maybe healthier individual, this might not have had as much of an impact. Unfortunately for him, it did. And in that case, the government was put on notice. So, and we actually looked at the gap that was created by the installation of the stop sign just a block over. It actually made that intersection more dangerous because now you had these cars coming at a certain interval of time that it takes to stop and then go. And so instead of a bunch of cars going all at once and then maybe a stop in traffic, they were all timed at an interval that didn't allow the stop sign traffic to go, which was causing buildup. And it was actually really interesting reading the collision reports, but reading the traffic studies, you could see a reorientation. So I believe it was 2022 the incident happened. So in 2021, I believe the report said it would add, some absurd number to commute times. And the 2022 report after the incident, where they actually installed a four-way stop, they re-evaluated the time it would, cost drivers to install a four-way stop and actually said it would lessen the commute time because of the traffic it was causing. So these are just kind of tidbits you can look at and point to, especially when you're looking at data that you want to be able to look at data holistically and not just use what's being provided to you. And so, I mean, in this case, it was nice because they updated it right after the collision to say traffic would have actually gone down. But you want to make sure your experts are looking at that. And I mean, I think a common argument you're going to get is, well, we want to balance safety and efficiency. And by installing certain traffic control devices, we're going to back up traffic, which community members don't like. But oftentimes that's not the case. And that wasn't in this instance. And I think you'll see safety doesn't always mean a reduced efficiency. So we need to look at that balance and it helps you tell that story. When you're structuring your case early on, you're going to want to pull the jury instructions. And this will help you tremendously when you're looking at what questions to ask in deposition, what admissions you need from the government, how you're requesting discovery, your request for admissions. You want to easily be able to pop in the box from the jury instructions. I gotta prove this, this, and this is what I'm gonna do. So make it really mathematical almost in a way. Preserve all the physical evidence. So make sure the vehicle's not destroyed. You're going to want an accident reconstructionist. Send spoliation letters. It's really easy now to just go online and look at nearby businesses and send out letters right from there and say if you have any video footage. Um, I like knocking on doors. Sometimes there's ring footage. You're going to want to make sure that you can gather as much evidence as possible. Send your accident reconstructionists out early so they can do, those drone 3D footages and kind of preserve what the area looked like, especially during that season, whether there's brush that might have been overgrown in the spring. There's a lot of things that you want to do early on in a case that'll save you in the future. And briefly, just some final takeaways. These are long cases. They typically go on for longer. There's a lot of documents you're going to be looking at. But they're high impact. A lot of times your community is sharing with the government that something needs to be done and it's not being taken care of. Um, their efforts are falling on deaf ears. It often happens in lower socioeconomic areas. Uh, so I think they're high effort, but they're high impact. You're gonna ideally create safer conditions for the next road user. Big takeaway, not every bad crash is a bad design. You want to look at that misuse. You want to see if this is an anomaly. And on the reverse of that, good cases involve clear history of complaints. So you're gonna want to ask for that complaint history up front and contact those people to see what exactly their issue has been. You want to see the same pattern. So in that case I talked about in Fife, where it was, a four-way intersection would have helped. A lot of people were getting involved with collisions where the stop sign was misjudged the follow through and ended up hitting the car that was going straight. Foreseeable misuse. So speeding. If there's a history of speeding on the roadway, that's foreseeable for the government to be able to do something about. If it's foreseeable that someone's going through a closure that they have no business closing and there's an easy fix, that's foreseeable. They should do something about that. And it's always nice when there is a clean story about what should have been done. So it's not enough to say, I think especially in highway design cases, it's not enough to just say this is dangerous. You almost need to come up with the fix itself. And I think that's really important for whether it was reasonable, because we do engage with a world that isn't completely safe, but is a safer alternative readily available. And that is my um, presentation so far, but I have questions, so I wanted to open it up to anyone that had questions. Hmm, I don't know if I can see. Let me stop. I don't see any questions. Well, thank you. Oh, let me see. Oh, this is great. Courtney asked average cost of experts on a case. I think you can run into the six figures easily. And depending on how far the issue goes back, uh, yeah, 150 plus, 150,000 plus. And I think also depending on how complex it is, you're going to want to talk with your expert a lot when you're going through the stages of discovery. So any information that they're going to need. And I believe Cassie has opened up the CLE attendance confirmation, so feel free to enter your WSBA bar number to confirm attendance.
Perfect. Oh, I see you have another question.
Oh, government makes a change to the design, so it shows that it's feasible. It's still, uh, uh, I know theoretically you can't bring it in, but you always find a way to bring in that change. Um, it doesn't need to show that there's the rule basically that, we don't want to discourage the government doing the right thing after, but oftentimes it shows feasibility. But I mean, it's great, especially when they do make the change. I think that's really important, and oftentimes it does take you filing a lawsuit. So after the one in Fife, after we filed within 3 months, there was a four-way stop. So it's not that they're unable to do these things quickly. And what's nice is you talk to your expert and you're like, well, how did this happen? And in the Fife case, it was just government bureaucracy. And unfortunately, people just pawning it off as not my problem. Um, Answering constituents saying like, well, it doesn't meet this factor, where you're going to take a police officer's word that one block down, somehow their word is more valuable than you have neighbors complaining about the same thing up a block. Yeah, yeah, David provided the answer to Courtney. So yeah, you open up the door to admissibility if they claim it wasn't feasible, you weren't able to do it, the cost was too high, and oftentimes that's not the case. How do you deal with government responses to public records requests requiring a promise the results not be used? Re lawsuit. I'm a little bit confused by Jessica's question. Um, are you talking about kind of the RCW that's at the top of the PRR? Well, one, we're gonna get the PRR request through litigation anyway. I haven't seen it be an issue. I think what you're talking about, Jessica, is like when there's ever like a draft proposal, there's like a top like RCW, da 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 da. This is just a draft proposal, nothing can be used against us. I haven't run into any issues with that, and it can be used for other purposes. I've seen it a couple times and kind of just ignore it. Um, but yeah, I don't really know how it holds water. Um, what are the typical expert categories you retain? Thanks, Courtney, for the questions. So oftentimes, so traffic engineer, but within those specialties, we have one that deals primarily with signage. And so that's really important. And then our normal traffic engineer, PhD engineer, civil engineer that looks at the traffic studies. And I think it's really helpful when you go in to talk with your expert, you have an idea of the layout of the area and kind of the changes in the area because that might not come back initially. And so being able to fill in those blanks of, oh yeah, like the neighbors were complaining this was used as cut through traffic. Um, this is stuff that county engineers, government engineers, they should have that information. They should be thinking through those issues as they're designing the roadway. Like, oh, we're putting up this huge apartment building, or, the traffic on this road just completely dropped off because we closed it down for a couple months to deal with this construction project. But it might not be something that your engineer is looking at immediately. So having that background information, I think, is really helpful. Any other questions? All right. Well, thank you all. And feel free to reach out with any other questions. My email is just my name at Strip Matter.
Thank
But
you.
it's been a pleasure.
Thank you so much, Furhad. That was a great presentation. If everyone could please also fill out the survey form at the end and take a look at our upcoming CLEs. We have two coming up in September, so be sure to register. Thank you, Furhad. Thanks, everyone. Bye.